name is Jennifer McLaren, and I'm with the Office of County Counsel. I represent the Child Welfare Agency in juvenile court.
My name is David Myers. I'm a lawyer who represents parents and children in dependency proceedings.
Hi, my name is Tracy Lee, and I'm also with the Office of County Counsel and also represent the Child Welfare Agency in juvenile dependency court.
If you're watching this, chances are you are a new social worker and you've been told to watch this video by your supervisor. And you are a family reunification social worker about to head into court for your review hearing. This video will explain the court process and help you achieve your goal, which is to get the court to adopt your recommended findings and orders. And in order to do that, you need to figure out how to write a report.
So what's the secret to writing a great report? Our suggestion is you start with your recommended findings and orders. That's what you're asking the court to adopt. So working backwards, saying what am I going to ask the court to adopt and what evidence do I have? What information am I presenting to the court and the participants in the proceedings to support that recommendation? They're going to direct you on how to write your report.
That's right. And remember, if we're talking about a review hearing, that's called a 6-month hearing or a 12-month or 18-month, which we'll talk about. A lot has happened before this point. The lawyers have met their clients and have had a relationship with their clients. Hopefully a lot has been happening during that 6 months. That's not just your work, but hopefully there's been meetings, there's been conversations, there's been plans, there's been revisions and all kinds of things. And sometimes there have even been court hearings before that first 6-month hearing. And so before you walk into court, you have to know that a lot has already happened, impressions have already been formed. Jen, let's talk a little bit about the 6-month review hearing.
All right, so the 6-month review hearing is guided by Welfare and Institution Code Section 366.21e. And at this point, the court is really looking at returning to the parents. The statute specifically says the court shall return unless. The court has some options at the review hearing. They are looking to, like I said, return. If they can't return, continue services. They can terminate services. And we'll look at a little at each of these more closely. So for return, why would this occur?
If the agency wants to keep a child out of the home, they have to show by a preponderance of the evidence, which is more likely than not, that there would be a substantial risk of detriment. If they can't meet that burden, that child will go home. They will also look at the progress the parents have made over that 6-month period. They'll, of course, also look at it from a very child-centered point of view.
And that's why it's important when you're making your recommendation to use your good social worker practice and your social worker education, going over your safety-oriented practice and your SDM, staffing with your supervisor and your county counsel.
And so when return can't happen, though, there are other options. Can you talk about those?
Sure. So when we're talking about termination of services, the agency must show by clear and convincing evidence, which is more than a preponderance, not as much as beyond a reasonable doubt, convincing evidence that the parent didn't participate regularly, that they failed to make substantive progress, and that can be difficult to show in some cases. If the child's over 3, you're going to move on to a 12-month hearing.
So Tracy, what's the difference between a 6-month and a 12-month hearing, or is there?
Well, the 12-month hearing is governed by Welfare and Institution Code Section 366.21f, and is very similar to a 6-month hearing. The court shall return, same burden, same options, return, terminate services, except
the 12-month hearing is a little harder on the parents. If a parent is going to continue services, if return doesn't happen and you're at a 12-month hearing and you want to recommend continued services, you actually have to show, and the parents have to show, a little bit more, like it's a substantial probability that that child's going to come home. So to get from 6 to 12 is not so hard for parents who are really trying. To get from 12 to 18, much harder. And the law is 366.21 subdivision G, and those factors lawyers and judges will look at very, very closely at 12-month hearings. And so at that point, whether you're going to return, continue services, or stop services is highly dependent on how the court weighs the evidence based on these particular legal parameters. So if we move on to the 18-month hearing, Jen, can you talk a little bit about the differences between that hearing and these other two?
Yes. The 18-month hearing is really the end of the reunification period for most people. At that time, it really is where termination of services is looked at, and the court either must return or terminate services. And there are some exceptions. If the parent has been incarcerated or if there's other exceptional circumstances shown, the family reunification period can be extended to 24 months. Specifically if a parent is incarcerated or if they have been deported. And if the court does make those findings and does set a hearing out to the 24-month period, that hearing is then the 366.25 hearing.
That's pretty rare.
It is. I don't know that I've actually ever seen it.
It can happen, but let's talk a little bit about how you can help your attorney ensure that the court adopts your recommendations.
Thank you. So one of the things that happens in court is talking about the weight of the evidence, how the court should weigh that evidence, the evidence that you've provided in your report to the court and the participating parties. Key to that is importance of visitation and the quality of that visitation, really documenting that in your report. The relationship between the progress in services and the risk of return. Was it just I checked it off and I did the service, or did they actually benefit from that service? And what evidence do you have to support that or to provide to the court that the parent did not benefit? And what is the relationship of that to the risk of return of this child to the care and the custody of the parent? Some of the complicating factors that can come into play, as you know, are relationship between the social worker and the parents, relationships between mom and dad, and between the children. Changed or new barriers that have come forward. As Dave said earlier, these are families, these are complicated lives that you're dealing with, and you've now been with this case either 6, 12, or 18, maybe even 24 months. And there are changed circumstances and new barriers that come before you.
Absolutely. So how do they help you win, Jen?
Well, as a county counsel, I cannot tell you how important it is to work with your county counsel throughout the reunification period and remaining in communication as issues pop up will help you be in a better position to write a report that will get the court to comply with your recommendation. So you want to make sure that your report is well informed, that it contains the relevant and appropriate information for the court to consider. That you remember, again, you are a neutral investigator of the facts. You are an arm of the court in many ways. And so your information is to gather, your job is to gather the information and put it before the court. You want to make sure that you work with your attorney so that they are aware of what's happening on the case, and you need to be objective in your communication.
It's not helping your attorney win in court. It's making sure that the information is being provided to the court and that the court can make the most reasoned decision and most appropriate decision for the children and family before them.
Your court experience will vary depending, of course, on the people and personalities in those courtrooms. But the better prepared you are and the more you communicate, the better your experience. And we hope you have a pleasant experience at your first time, and the more you do this, I think the more fun it becomes. Thank you.